2 years to try to introduce our members to new parts of the world, to create new networking opportunities, and to take alumni from the Frankfurt event, the London conference, and from earlier globals, and create new opportunities for them to be in different parts of the world that haven't been before. So over the last decade or so, we've been to Amsterdam, Paris, Shanghai, Sao Paulo, Prague, and in late March of 2023, we will be in Buenos Aires, Argentina. We had meant to be there a while ago, but the pandemic delayed us a little, so it'll be 4 years between instead of 2 years. But we're very excited to be back on the road and to be back talking about international white-collar crime with various groups like this. And so what we thought to do in this panel is to take a look back at the last 10 years. What are the trends that we've seen? How much has changed in those 10 years? And it's been a lot. And then to take that knowledge and to think forward a little bit about what the next decade holds and where trends are leading us and what directions those might be. We encourage the audience. We would love participation. We're going to have what I think we can describe as a conversation up here. I'm going to throw out different topics, and we're just going to go back and forth. We're coming from different perspectives, and I'll introduce all of our speakers in just a moment. But we'd love for you to engage in that as well. So no need to hold questions or comments until the end. If you've got something you want to share, we would love to hear from you. So just raise your hand, and we'll bring you into our conversation. We'll also try to reserve a little bit of time at the end for those who would prefer to wait until that point to ask questions or make some comments. Let me then introduce our panel, and then we'll jump right in on our first topic for the day. So my immediate left, Anand Doobay, deals with criminal and regulatory matters based here in London. He deals with matters including fraud, extradition, mutual legal assistance, corruption, sanctions, tax, and money laundering. He has advised a serving prime minister, a former deputy prime minister, a deputy foreign minister, and 3 G20 governments. He's also been involved in high-profile and politically sensitive investigations and prosecutions in over 50 countries. Another thing I will note that has changed in the last decade is I didn't have to use these to read stuff. When I was in Frankfurt back in 2012, was the first one of those. So anyways, here we are. Next is from Paris, Yousr Khalil, partner at FRA and head of FRA's Paris office. She is a forensic accountant with almost 20 years experience delivering forensic accounting services in support of multi-jurisdictional investigations and developing and testing compliance programs and complex dispute resolutions and arbitrations in the U.S., Latin America, Europe, North Africa, the Middle East, and Asia. To her immediate left, Amanda Pinto, QC, from here in London as well. I'm sorry, Casey, my apologies, Casey. A specialist barrister in corporate crime, fraud, corruption, and money laundering in chambers at 33 Chancery Lane. She is a nominee for the Legal 500's Casey of the Year for Corporate Crime, and in 2020 was chair of the Bar Council of England and Wales. And finally, at the end of the table, we are honored to be joined by Lisa Van de Waal. I will note that if you look at your program, Tobias from Germany was originally slated to be with us, but was unable to be here today. And so we're very, very thankful that Lisa was willing to jump onto this panel and help us out with these very interesting and cutting-edge issues. She joins us from De Roos and Penn in the Netherlands, where she is a partner. She has extensive experience in providing legal aid in large and complex international fraud cases. She also served as an editor for the Journal of Company and Criminal Law and as an interim judge in the District Court of the Middle Court of the Netherlands. So we're very honored to have this group here. I'm very excited to be able to engage with them and talk about these issues that we've identified for you today. And so let me jump right in. Yousr, I'm going to go to you for starting us off on this first issue. And the first issue to talk about today is the growth and the development of international cooperation. And as an aside, to kind of get us thinking about this issue, I'll say, when we were speaking in Germany, in Frankfurt, at that first International White-Collar Crime Conference, many years ago now, I distinctly remember many of the panelists saying things like, there's a lot of competition between governments. There's a lack of cooperation between entities. It's a race to see who can sort of get to the case first to get the settlement. And my personal experience is the world has changed a lot in this respect in the last decade. So I'd be interested to hear what you think. the world the same as it was 10 years ago, or are we in a very different place now?
Thank you very much. I'd like to start by saying that everything I'm about to say has been said earlier this morning. Because between Max Hill confirming that the prosecution is looking for global enforcement and cooperation, and it will continue to be the same. Jim Thompson mentioned the repo method and how the cooperation across all of these. So these are active, live, recent examples of how cooperation continues because of the investigations of multi-jurisdictional matters continues to touch on the companies that we represent. So it's not a question of whether there is global cooperation. It's not a question of enforcement, it's just a question of when. And earlier, the other panel just before, Kara mentioned that, well, sanction is the new SCPA, so here's your enforcement landscape for the next 5 to 10 years. Thank you very much. The US had very strong ties with Brazil, so in 2022, just this year, they've had one of another dual enforcement was the Brazilian authorities with Cycle for SCPA enforcement. Before that, there was the famous Airbus matter, which was a global coordinated settlement between the French, the SFO, the French PNF, the UK SFO, and the DOJ and the Department of State, all happening on the same day, on the 30th of January. And that is a big testament to the cooperation and the exchange of information that took place amongst all of these enforcement agencies and jurisdictions for both FCPA matter as well as IFAR infraction. Earlier than that, I've had the opportunity to work on the Talia matter, and I saw that DOJ, SEC, the OAP in the Netherlands, as well as Sweden authorities working on the Talia matter, trying to bring that to conclusion, which was really challenging because Sweden did not have and continues to be lacking a structure that allows it to reach a negotiated settlement. Glencore made just a few months ago, the US, Brazil, they will be facing charges in front of the UK in November of 2022 and waiting settlement with the Netherlands as well as Switzerland at the end of this year and maybe sometime later on. So it's not really a question of is it going to happen, it's a question of it's actually happening. The challenge here, as Chris has mentioned this morning, is the lack of harmony from the defense side that allows the company to coordinate, to work with the authorities while respecting the French blocking statutes in France, so it's not becoming a blocking and delaying statute from the DOJ perspective, the transfer of data from the GDPR. It's not just on the company to figure out the solution. If there is cooperation between the authorities and the agencies, they should, well, I'd like them to be also be considering how that works for the companies and their related defense. We're also seeing a bit of an uptick in the relationship between the US and South Africa in similar enforcement. And from our perspective, I think there's going to be a similar uptick between the enforcement authorities and South Korea, because there's a lot of banking investigations over there on fraud and embezzlement that touches upon money laundering. So that's going to be another area for you to be seeing cooperation on that front. So without further ado, I'll just give it back to you, Lucian, on that.
Can I just add something? So I've just finished prosecuting a case with serious fraud offers that was a boutique and a fraud by supposedly investing in boutique foundations in Brazil. And so there is cooperation in terms of global settlements and really what you're talking about. But I think even at a more basic level, the SFO has incredible cooperation from lots of centres, financial centres around the world dealing with getting bank accounts and financial statements to us. The Middle East, where there were also corporates set up, Brazil, in terms not just of cooperation in terms of getting the accounts and so on to us, but also in actually setting up meetings so that witness statements can be taken from witnesses, and that completely changed the landscape of what the case looked like on a really basic level. So we at one point called, or would have called, except it all agreed, 17 or 18 witnesses of very different types, landowners, people who had actually sort of farm workers, all sorts of different people in Brazil who were involved in the case, including lawyers. So that is a really basic level at which it also has had an enormous impact, I think, without it necessarily having to be very high level.
So it sounds like a lot more cooperation happening. Lisa, Anand, what do you see? Something similar or something different?
Something similar in the Netherlands. Recently, a press release was brought out by the Dutch Public Prosecuting Service regarding money laundering issues and confiscation. Of course, again, they want to focus more on that. It's a bit of a repetitive story, not only in the last 10 years, but also before that. And I expect the next 10 years and the next 20 years we will read the same. But again, they are also stressing they want to focus more on international cooperation because all the potential criminals are elsewhere or partly elsewhere or working together with people elsewhere. So yes, I see the same development.
Can I just add a note of caution? Because I think there are still some tensions in terms of the way these relationships work. I certainly have seen examples of where the dominant party in the relationship can determine the course of the investigation. I think there is still a race to the end. So if there is going to be a global settlement, i.e. there's one or more countries that's going to enter into a settlement, that can put pressure on another country to speed up their investigation to be part of that global settlement. So I think there is certainly more communication. I think there's certainly more interaction in terms of evidence gathering. But in terms of coordinating the outcomes of investigations, I think there still can be tensions in terms of timing, pace, and outcomes. And you can still end up in a situation where essentially one country is having to make a decision, do I want to just be part of this resolution or do I not?
Yes, I think this is a great setup for what we're going to be talking about for the rest of our time here. In many respects, the world is a lot smaller. There is a lot more cooperation happening, but at the same time, tensions continue to exist. Laws continue to evolve at different paces and in different directions, depending on where you are in the world. And so I think what we're going to find is we're going to find different trends moving in different directions over the last 10 years, signaling kind of where we might see some tension and cooperation in the future. A couple things that I'll note from the comments that we just heard. I think one question is, what do we mean by who is cooperating? I think that's a broad concept. We've kind of narrowly been talking about enforcement bodies here, but you also heard some discussion about internal investigations, which we're about to focus on in a minute here, the role of corporations and their cooperation globally, as opposed to maybe 10 years ago, there was a very sort of, formalized relationship between the DOJ and entities that it was investigating under a U.S. principle of prosecution. That has really begun to move in a more global sense, and a lot of countries have started to look to those types of issues. So we'll explore that a little bit today. I'll also note that one thing that I think looks very different is, from a more formalistic perspective, there's a lot of task forces today, right? So whereas it used to be that a lot of enforcement entities would stand alone, there may be some kind of informal relationship where they would cooperate with one another. There's a lot of task forces that work in different spaces today, like with regards to tax and money laundering. And I think that is leading to a lot of new investigation and a lot of sort of spillover focus. So where one body is interested, one country is interested in an issue, these task forces, and because of their collaborative nature, are leading to those becoming issues of dominance and issues of importance in other parts of the world as well. So I do think we're seeing a trend where there's a lot of cooperation, there's a lot of talking going on, but at the end of the day, there's got to be a settlement, and that's where we may be able to see some of the tensions that we were talking about 10 years ago sort of rearing up once again, even though we're maybe in a different place, generally speaking. We always like to, when we do these, we go all over the place. We do like to focus a little bit on the place we are in these conversations, as well as obviously talking more globally in a panel like this. So we do want to just step back for a moment, and we're going to ask Amanda if she would talk to us a little bit about the FSO in particular. We've obviously heard a lot from the FSO here over the last decade. We've obviously followed it. What's been going on with the FSO, and what does it tell us, do you think, about maybe where things are heading next, particularly with regard to the UK, as part of this global enforcement community?
Sure, well, I think one of the things to say is that over the last 10 years, I think the kind of reputation in the global community and where the SFO is has changed, and I think it's partly to do with what's been going on internally within the SFO in the UK, and partly sort of more general, but I think the first really does inform second. As you all probably know, between 2012 and 2018, David Green was the director of the Serious Fraud Office. And for the first half of the decade that we're now thinking about, I'd say that the SFO's reputation really improved. I mean, to be honest, if you've ever heard David Green speak, he says, "Oh, my advice to anybody taking a new job is follow someone who wasn't very good at it." So in one sense, that's the only way perhaps that you can say it was obvious that the reputation of the Serious Fraud Office was going to improve, because it wasn't a very high standard. However, he did suffer from a couple of really huge issues, one of which was existential. Our then Home Secretary, Theresa May, spent a large amount of her time trying to get rid of the Serious Fraud Office and to sort of put it into the NCA, the National Crime Agency. And secondly, there was a really, really significant issue with funding. So he spent an enormous amount of time internally trying to deal with those things. And then during the course of that time, he started a lot of investigations, some of which obviously didn't come to court until he had left and Lisa Rostovsky became the director. And her emphasis, and I've heard her, I think, speak to this meeting, was really very much on international cooperation. And I think looking at what was going on in the UK with very much American background as her focus, and a much more American approach to investigation, the greater use of DPAs, for example. And it looked like the UK might become a great collaborative partner on the global stage, but actually the last few years, I would say, have been a torrid time for the SFO, and there has been the growth of DPAs, but we're going to talk about them later, so I won't say very much now, but it hasn't all gone entirely according to what I think the plan might have been. Because one of the things is that it has also, apart from the successes of DPAs, if that is what they are, it's been characterised by the consequent failure to get convictions for individuals. And I think all of those issues, those types of issues, and the press is quite critical actually of serious fraud. So you very rarely see positive reporting. I think that impacts on the way that the Serious Fraud Office is viewed globally, and a lot of the problems that the SFO has had, I think, are a distraction to the cooperation and the very real strides that have been made, not just in investigating and prosecuting offences, but in dealing with the proceeds of crime, confiscation and asset forfeiture, etc. So I would say that there are some positives, but actually I think there's been quite a bit of reputational fallout from SFO failures in terms of disclosure regimes and either stopping prosecutions entirely or appeals that have been successful have actually had a very significant impact, I would say, on their reputation.
Let me ask you about what you think this indicates for the next decade with regard to the role of the FSO in this global enforcement community, in this cooperative community. I'll just note that to Amanda's point about the prosecution of individuals, the US DOJ went through something similar. So coming out of the US financial crisis in the late 2000s, there was a lot of focus on corporations, not a lot of focus on individuals, and that led to the issuance of the Yates memo, Sally Yates' memo, basically saying we're going to try to better coordinate these things so that our investigations of corporations lead to prosecutions of individuals. So that was a real, I think, change or a shift that we saw resulting in the U.S. similar phenomenon, and I don't know if that's what people think will happen here or if something else is going to come from this trend that you observe. Would you agree?
No, sorry, I can't answer the question for the SFO, of course, but I can answer it for the Dutch perspective. There's always been a focus on companies and individuals. Only what we see is when large settlements are negotiated, and we have them in the past years, you know, all the IG, ABN AMRO, and a lot of other large settlements. According to Dutch perspective, that's what we learned from the US, I think, to try to get huge settlements. And at first, in all the settlements, well, the individuals were kind of co-negotiated, so their cases were dismissed and no particular investigation or prosecution for them. That the public was critical about that, and saying, you know, companies can pay this amount of money for a settlement, can pay the illegally obtained profits, and no natural person have to, is now responsible for this criminal offense. And a company, of course, is a company, but there must be individuals who really committed the criminal offense. So there's what we see in the more recent settlements. It's always stated in the press release and in the statement of facts that the individuals will be prosecuted, but actually we haven't seen that yet. The investigation is still pending and keeps on pending. So I'm really, well, in one example actually the natural persons were also settled and dismissed. So it's always a tension because, you know, as a company you would want to settle everything, because if you're an individual, your employees are going to court as well. The damages again done by reputational issues.
I think also if you can't successfully prosecute individuals, you lose the risk. So one of the things which often persuades companies to enter into PPAs, to self-report, is the risk that individuals face that they might be prosecuted, and the companies face. So again, the SFO has not had a very good track record of prosecuting companies where they've chosen to do so. There's some pretty spectacular failures. And I think if you know, to speak to your point, you may have an appetite to do it, but if you can't do it successfully, then over time you lose people's sense of jeopardy in terms of the SFO being able to discover and successfully prosecute, which can ruin your plan to have lots of DPAs and lots of expensive settlements.
So clearly, you know, we talk a lot about the role of corporate criminal liability, and we will come back to that later in our panel discussion, but intimately intertwined with individual liability, particularly in a space like the white-collar space and the international white-collar space where we talk so often of settlement and DPA. So I think we'll come back to all of those issues shortly. Before we do get to those issues of settlement, though, I think, you know, if we're going to have a conversation about what the last 10 years have looked like, I think the natural starting place was to talk about the growth of cooperation and how that looks a little bit different today, contemplate perhaps the role of the FSO in particular, because that has changed so much over the last decade, and it's sort of finding these new spaces to be in. But I think we also have to talk about internal investigations, because certainly from the U.S. perspective 10 years ago, you know, when we talk about a government investigation, you would always, hand in hand with that, talk about an internal investigation, because the government, really for decades at that point in the U.S., had already been relying on private outside counsel to do these kind of inquiries. You know, historically, that really dates back to at least the 1960s. We first began to see it with the SEC in the 1960s with regards to corporations that had entered into agreements with them. The SEC just did not have the personnel to monitor them very well. And so that kind of evolved from a more formalistic court-ordered personnel who did this sort of like a receiver in a bankruptcy proceeding to what we've come to know as this sort of independent third-party outside counsel. And with the growth of the Foreign Corrupt Practices Act in the 1970s, it was just sort of a natural growth from the SEC perspective that the DOJ would start to use it in criminal enforcement as well, and sort of that private counsel would begin to take over a lot of the investigatory role. And I think, you know, in a global sense, you know, internal investigations, that first Frankfurt conference was just on that one topic. You know, how do international internal investigations work? Because 10 or 12 years ago, when we talked about that, you know, they were were certainly occurring, but I don't think with the kind of frequency that we see them today. And so let's pivot our conversation a little bit to that part of the investigation. The part of the investigation that's done by counsel and that relates to this idea of internal investigations work. And the first question that I want to ask, and I'll direct this to Lisa first to get us started, and then we'll hear from the group about what their experiences have been and where they think this is headed. You know, in Frankfurt 10, 12 years ago, we were really focusing on an accounting fraud or a classic fraud case, and those were the kind of things we were seeing in global investigations with regard to. But now the universe, the scope of internal inquiries is much, much broader than it used to be. So tell us a little bit about what you're seeing in this space as it's evolved over the last decade.
Yes, thanks, Lucian. I will go back to your specific question a bit later on. But first, drawing the landscape of internal investigations in the Netherlands. As in other parts of the world, we have seen an increase of them in the last 10 years. And with the growth of the internal investigations conducted by attorneys, by lawyers, lots of criticisms was voiced. For example, by forensic accountants, bankruptcy trustees, members of parliament, and also some journalists in the Netherlands from financial newspapers are very critical to the role of the attorney investigator. And basically, that criticism focused on that the investigations are presented as independent fraud investigations. And the criticism focus also on the fact that being an independent investigation is misleading for the reader and to the public. Because saying as an attorney you conducted an objective and independent investigation is contrary to us, to one of our core values, being a partisan advocate. To focus on a little bit more on what Lucian was just saying about and the enforcement agency trusting on the results of the internal investigations. In the Netherlands, there has been what I call an experiment. Sorry, Marlene, hopefully you don't mind. After the financial investigator started an investigation, and the company says, okay, we will do the investigation ourselves and then hand over the results, and for you, public prosecutor, you can validate and verify the investigation. So it was meant to be, to have the investigation more efficient, quicker, and less, to draw less resources than for the financial investigating service. I know, but maybe Marlene can weigh in, there have been some investigations on this part, but it didn't really turn out to be a good result. Also there was a lot of criticism. For example, what do you do with your employee being interviewed according to employment law, your grounds to answer questions, but on the other hand, your employer already knows that this interview, or at least some of the interview, will be handed over to the prosecuting authorities. So all these kind of issues, there's much more to say about it. We can fill in a panel separately about it. So that all these topics are, there's a lot of discussion about it in the Netherlands. What I was just saying about the criticism of it not being an independent investigation, in the last few years there have been quite some disciplinary complaints against attorney investigators by individuals being investigated or by the other parties. And it focuses on that the investigation was factual wrong, it was incomplete by leaving some facts out, of not investigating everything, and that the report was drafted or was in wording too positive. There have been various verdicts by disciplinary courts in the Netherlands, and recently there was one which I would like to discuss in short, because what the disciplinary court group there was regarded an internal investigation of which the report was used externally to a financial authority, supervisory authority I should say, And the court said you as an attorney knew or should have known that it was used externally, so you have to meet specific requirements and you did not meet them. So you cannot be treated as an independent attorney investigator. And for example, there was no confrontation for the man who was investigated with the findings. According to the disciplinary court, not all relevant facts were included in the report, and there was also basis for misunderstanding. And what the disciplinary court actually did, and I think that is quite, well, it is new for us, and I'm very curious to hear whether in other jurisdictions the same discussion is pending, that the disciplinary court made a distinction between internal investigations that stays internal and on which you as an attorney gives advice to your client and build up your case, and internal investigations which will be presented outside. And if you read the verdict of the court correctly, then they actually say as an attorney you cannot do internal investigations that will be presented to external parties. So there's a lot of discussion going on what should be done now. Should you hire, because I forgot an important factor. The court also says if you already advise the client, sometimes on the same issues that are part of the internal investigation, but also subsequent to the internal investigation by defending them in court or litigating against an employee, for example, that means that you're not, that those two aspects cannot be put together. So, and that's what I said earlier, it's contrary to the core value of partisan democracy. So we really have to see where the discussion goes, because would it be sufficient if we hire another law firm not involved in this client at all to conduct the internal investigation? But what about legal privilege issues? So actually we have to wait the next verdict about this particular topic.
Well, and that's how the scope issue, the scope of the investigation can really raise all kinds of concerns. And I think part of this scope issue relates to the fact that we are seeing investigations in very different spaces than we used to. So when it was sort of very succinctly a criminal fraud type investigation, I think the lines were a little easier to draw. You knew that it had to be outside of the investigatory counsel. You wouldn't want people inside the corporation investigating that kind of a matter because it wouldn't carry the kind of weight that you described, because of the independence issue. But now we have investigations relating to ESG matters, the Me Too movement. The investigatory structure looks very different than it used to be, and that I think is leading to some of these things where, for instance, I think we're seeing, from what I've heard from the panel thus far, more examples of corporations doing their own investigations before bringing in third parties. Is that what others are seeing? And what do you think about that trend and how it relates to that independence notion that's supposed to come with these inquiries?
I think there's a sort of distinction potentially between the US and the UK here, because I'm not sure that certainly serious fraud, I don't think sees itself as outsourcing its investigation. I think lots of companies, before they make a decision to self-report, want to know whether they need to self-report. So they're in fact investigating whether there's something that's criminal that's gone wrong that they need to report about. And I think that's a sort of self-contained exercise, but then there's a tension between that and the criminal investigators who obviously want evidential integrity, and therefore they want to know that the evidence they're going to gather, if there is a self-report, isn't contaminated by what the company has done. And you can see that in terms of the guidance that's given about how companies should operate and how they should deal with witnesses. And you can see it in some of the real cases of DPAs where extra credit is given, where companies have agreed to suspend their internal investigations pending the outcome. So, because companies also want to deal with other things by their internal investigation. They want to know what their civil liability is. They want to understand what their shareholder accounts might be. So I think there are some competing tensions. very straightforward if you're just doing an exercise to work through a criminal file, as I said before. But it's never just that. You know, it's always more than just that, which is why it becomes more complex.
And I think one of the things is that everything obviously always starts from a fact-specific situation that no one was probably anticipating. And certainly I've had experience of the SFO or the CPS given an investigation at the time that there was one company trying to do another for what looked like corrupt bribes to a manager. And actually what they really wanted was to get the money back, and that was their first intention. And this was a kind of peripheral thing to put pressure on.
So let me go back to this issue that Anand had raised and ask him to speak a little bit more about it. Because I think as we think about the scope of investigations being different, they're touching on different areas now. Obviously, because they're cross-border, different enforcement bodies perceive these differently. So whereas the DOJ has sort of relied in many ways for decades now on the work of independent counsel to dig into the matter and then provide them with the evidence they need, either to settle or prosecute the company and to prosecute individuals as well. It sounds like the SFO has taken a different tack in other jurisdictions as well. What's the relationship then today between enforcement bodies and internal investigators, and how has that changed over the last decade as each of these have sort of begun to evolve into this new space?
Yeah, I'm not sure there's one answer to it. So I think the SFO certainly had a lot of bad experiences where there have been internal investigations conducted before they began investigating. So there have been cases where essentially they have disclosure failures because they've simply taken material that's been given to them by the company's lawyers and they've not collected their own material. They've had instances where they've been relying upon the company's lawyers who conducted the investigation to give evidence at the trial. And those lawyers have, at the end, decided not to because they have their own concerns about their own risks. And I think also the SFO and other investigation authorities have really had to struggle to understand that these aren't independent investigations. These are investigations conducted by lawyers instructed by the company. And the lawyers can quite legitimately cast these things in the best light for the company. It's not that they're lying or not telling the truth, but certainly they're advocating in some way. And if the SFO or another agency simply adopts that narrative without understanding that there are other interests involved, then they can become horrifically unstuck later on in their prosecutions, where they suddenly realise, well look, we accepted this as the narrative which we put forward, but actually we didn't really investigate it ourselves, we didn't gather all the data ourselves, we didn't gather the information ourselves, and now we have a real problem.
It is an interesting relationship that has developed over time. I wonder what others on the panel think about the roles that have been created and how they vary country to country. I mean, in the U.S., for example, obviously the DOJ is doing its own investigation as well, but it is very much reliant on the company to help provide that material. And there's very clearly an understanding that relationship exists because there is some level of trust there. And with regard to the employees and the individuals, I mean, one of the interesting cases we have in the U.S. is the Computer Associates case, where there were individuals at a company that was under investigation. The government actually said to the company, we want you to go out and do an investigation of what these individuals have done. They did that. During that investigation, two of the employees who turned out to be sort of behind the matter that was under inquiry allegedly lied to the internal investigators, who again, remember, are private counsel. When the internal investigators then provided that information to the DOJ said, we know that's not true because we have a whistleblower. And by the way, the two employees who lied to you, that was basically like they lied to us, so we're going to charge them with obstruction of justice. And so, I mean, that's sort of how close that relationship can become. And I wonder what the experience is in other countries, and whether that sort of relationship where there's almost, we describe it as a deputization in some ways, to get to that obstruction charge. Is that the trend that you're seeing, or do you see there being a more distinct deviation between the two?
So if I may, in France, the concept of internal investigation as it currently stands and we're describing it did not exist before someone did in 2017. And when the law came out, Airbus was already under investigation by SFO at the time. It took us a big effort to convince the PNF, the National Financial equivalent of the SFO, that the company is conducting internal investigation to support with the overall investigation. This is not how a prosecutor-defendant type relationship typically exists in France. But to Anand's point, the PNF followed the concept of eventually trust but still verify. And part of the company's cooperation was to allow them access to all of the information for them to do their internal investigations, their own verification of facts as represented by the defense counsel. Very proud to say that the PNF did not find anything that was not previously disclosed to them, so well done everyone for Airbus and the defense counsel. But on the other side, I'm supporting another client right now, which is subject to a whistleblower that went directly to PNF, gave these very big and outlandish accusation about bribes left, right, and center. And PNF at the time felt that they have sufficient evidence in the case that they did not want the company to conduct an internal investigation. And defense counsel was caught between a rock and a hard place because, well, how do I construct a defense case if I'm not allowed to talk to any of my individuals and gather the evidence, either A, to corroborate your allegation, or A, to defend, or B, to defend my client. So there is that dynamic that is still being developed as to what it really means to be able to conduct an internal investigation to support a regulatory investigation in that context, and to what extent can PNF and equivalent authorities in France would be able to rely on this, on that matter. The settlement for Airbus, the PNF made quite sure, as they were discussed in that particular hearing, they made quite sure to say, cite Airbus exemplary cooperation and the way they conducted the internal investigation. Just one last point, the law came in 2017. In January 2018 came a guidance that was jointly issued by the PNF and AFA, which is the agency that is supposed to be doing all the compliance audit and confirmations. And in that guidance, they said they provided elements as to how to calculate a gain calculation, and then also that you are expected to do an internal investigation, and you're expected to cooperate to get any benefits of that cooperation. But then, a couple of years later on, they said, no, we don't want you to do the internal investigation, so make up your mind, guys.
If I may just say this, one of the imperatives is a really boring one, but it's absolutely vital, I think, and will continue to have a huge impact, and that is the financial resources of prosecuting authorities in the UK are minimal and will reduce. And Max Hill earlier said 40% of crime here is economic crime. I think I'm right in saying it certainly is one-digit percent, but I think it's something like 2% of the various constabularies' budget goes on fraud, because they have to investigate and prosecute violent crime and gangs and sexual offences. They have to. And so they take the view, and I've actually heard in relation to a lot of financial crime, even insured, or, is there someone you can sue? Because if there is, we're not really interested. And that's all to do, I think, with resourcing. So it has to be really, really significant. But what the repercussion of that is that the authorities, whether it's the SFO or the CPS, rely on internal investigations to kickstart something for them to then kind of take forward. And what that does, as Anand said, is you've already got your narrative, and it might not even be the right narrative, but you've got it. It's really, really hard to either unpick it or take it in a different, take it in a kind of totally independent direction and see where the whole of the evidence leads you. Because you've already started from a position which has gone down.
Well, I think that conversation is wonderful because it brings us full circle on that investigation structure, which is the reason the SEC started to do this and to sort of move this investigatory structure outside of the agency, and why the DOJ embraced it after that was because it is so resource intensive that they didn't have the resources to do the investigation, so they let the corporations pay the bill by having private counsel do it. And as we've heard, there's a real tension in doing that because of this idea of, in Europe and the United Kingdom, do you really have the independence in that situation? But at the same time, as Amanda just pointed out, if you don't use that structure, do you have the resources to do the inquiry at all? or does it then go through unchecked? So I think that's what we're going to see in the next decade is a continued evolution of that.
No, I couldn't agree more. It was just not possible for a NATO such as Airbus to settle within 1 year. When we started negotiations much earlier on. But without, if you look at the team that was working for PNF, there were about 4 of them versus 7 law firms. And a team of, I don't know how many, 100-some to do doc review and the forensic accounting. I mean, there was just, the numbers don't just add up.
Right. Yeah, a classic example is the Siemens case. Almost 2,000 interviews conducted by private counsel in that case. One important body would have the resources to do that in a timely way.
Yeah, otherwise it would just be leave the company dry and being up to facing this potential settlement that never comes through.
But I suppose this is leading, I don't want to jump the gun substance, but this is leading us into, we're talking about corporate resolutions. So these are internal investigations which are aimed at establishing what has happened within the company. And so, if we come back down to where we were talking about earlier, the public wants to see who is responsible for crimes. They don't want, £100 million fine against the company only. And so I think at the moment, for me, I think enforcement is moving in a different direction, where the enforcement is starting from the perspective you need a corporate defendant who is willing to enter into a DPA who has got a lot of money to pay us. And then afterwards, well, now we need to prosecute someone. But you end up, the thing we're talking about, the narrative is to do a DPA, you need a statement of facts. Now, essentially, in practice, the statement of facts has to be agreed between the SFO and the company. But in real terms, the company will agree to anything because they want to close the settlement resolution. They don't really mind about the amount they're paying generally. So you end up with a statement of facts, which is in the company's interest to agree whatever the SFO want. It's in the company's interest to minimise the current exposure. So they would want to blame everyone who's left, the previous board, the previous subsidiaries, the previous employees. So you end up with the start of an investigation, potentially now, being the corporate resolution. But it's completely skewed the evidence gathering, the facts, the narrative, before we get to the prosecution of individuals.
And we've obviously seen a wording, and I think we'll take a quick detour and then we'll come right back to it because we have seen a real evolution in the prevalence of deferred compensation agreements in the last decade. And so we definitely want to spend a little bit of time on that. Quickly though, before we do get to that topic, we're going to cover a lot of ground here today. We've talked the last few minutes about, how we put together the evidence. And so I do want to spend just a moment talking about evidence gathering and then how complex that is in cross-border investigations. First, I want to talk a little bit about the government's collection of information. We've already just sort of talked a lot about the fact that a lot of that information and that narrative is coming from the corporations themselves. But it's also worth noting that the government has a lot of resources available to them to get additional information, beyond what the company is providing them as a result of their internal inquiry. If we think historically, we started off with this concept of letters rogatory, very slow, very cumbersome. Maybe you get a response, maybe you don't, but it's going to be a long time. And then we created MLATs. And interestingly, a little known fact, I think, is that the first 3 MLATs that the United States entered into, including with Switzerland, included not only the ability for the prosecution to use the MLAT to get evidence, but also allowed for the defense to use that same mechanism. And of course, that's not what we see any longer, right? That's changed. So now the MLATs are really just for the prosecution. And the newest evolution here is the Cloud Act. And the Cloud Act in the United States passed in 2018. It created the opportunity for executive to executive, government to government agreements that were even faster than MLATs. They would allow you to gather information very quickly and in compliance with any data privacy laws such as the GDPR. Thus far, there have only been 2 that I know of that have entered into, one with the United Kingdom and the United States and one with Australia and the United States. And I understand that there is some guidance that's going to be in place just shortly about that, so I think we're going to hear about that in just a moment. But I'll just note, this is like the MLAT, it does not include the defense. And so while the government seems to have found a lot of new mechanisms to assist them, the defense bar really hasn't been a part of that and hasn't benefited from that. And while the corporation may have its own methods of gathering this information, I think where you really see this become a significant issue is representing individuals and trying as a defense attorney to get that material. So throw it out to the group. What are your thoughts on the evolution of evidence gathering by the government, and do you think it's a level playing field at this point? Anybody?
Okay, I think I'll start with that. That's an easy question.
I think one of the issues is that if you don't, bearing in mind it isn't equal access to this material. The difficulty if you're a defendant is that your client may say to you, I've got some exculpatory emails. They're not in the material that you've got. So your risk is you say to the prosecution, we'd like to look at some more email material, and then comes back your fabulous exculpatory emails and thousands of ones which completely destroy your case. So you've got no control whatsoever over the exercise. And I think that is a really serious risk, even if you're able to engage the prosecution in either giving or even asking them to obtain material that can assist you or undermine your case. You actually are putting yourself at huge risk of exposure. I think that's where the real inequality stands.
And I think it's worth bearing in mind that we're no longer part of the European investigation, I think that's become the EU, but that proposal when it started didn't have a right for the defence to use it, but one is now built into it. So these things can change by way of sort of policy pressure. But I think that the biggest thing I think is that there seems to be developing a trend of trying to change the way mutual assistance works. So the Cloud Act agreement is one where in the UK it came into force last week, and we're going to see whether the overseas production, which is the mechanism that allows us to use it, will affect that. But at an EU level, there's an even more fundamental proposed change. It's the European Production Preservation Rules. And the idea is that in order to gain access to digital information, which in every case now you need, and generally in every case it's not in the country you're investigating in, that within the EU, every company which follows data has to appoint somebody to be a point of contact, and that you can make a direct request. So if you're an investigator in Germany, you just send your notice to Microsoft's office in France, and they will deal with your request and provide the data you need. Now that gives rise to all sorts of issues and questions, because you're no longer going through the central authority route to traditional mutual assistance. Who checks the privilege? Who checks to see that what's being given is relevant to the request and is wider than the request? Who do you complain to? How do you know? So there are lots of issues coming out, but I think that the thing that everyone's confronting is in the modern world, you need access to digital information, which is very rarely stored in the country in which investigations take place, and you need it quickly. And so these are sort of practical evolutions, but I'm not sure that as a defence lawyer, I'm not sure they really cater for the defence in terms of protections you would traditionally have associated with mutual assistance.
And I think, from the U.S. perspective, that is what is needed, is lobbying, essentially, to have the defense bar included as we create these new mechanisms for evidence gathering. So it's not a one-sided inquiry in that way. I'll also note to the point that was just made about the sort of informality that is developing. I think there has also been sort of an informality that existed, informally, I guess, for want of a better term, which is that in the U.S. it's been fairly common for quite some time for U.S. investigators to simply pick up the phone and informally call someone up to ask for the information. And then they receive the information from the foreign country, not pursuant to an MLAT or a letter of rogatory or anything, just kind of friend to friend. And then they go through it, and then once they find the information they need at trial, they then do an official MLAT request because they have to show where they got it from if they want it to be admissible. But the stuff that wasn't that helpful, it doesn't really matter, right, where they got it, because they're never going to ask to use it in court. And that has been an informal process in the U.S. And again, it raises all kinds of issues because that, in many respects, is just not available to the defense side. So that sort of, fishing around is unknown, hard to respond to, and, you only can see a small slice of what actually has been occurring. Do others want to comment on the government's ability to gather evidence and how that's changing?
Just a short remark, what you just said, because we have the possibility to ask for access to all the evidence gathered, which is not in the case file, so of course not selected by the public prosecutor relevant. But it also takes a lot of resources, of course, because sometimes you're in a room now, not like as big, but half as big as this, with only So we do have the possibility, but it's, yeah, sometimes it's just too expensive to do so. But sometimes you get, just what you said, Amanda, you find relevant disciplinary evidence. But it's always difficult. Same with the European investigation order. If a client if assets are seized or goods are seized, then you want to object to that. Some countries just does not allow you to have a copy of the investigating order. So it's difficult to defend yourself properly against that. Let alone how difficult it is to really have an effective legal remedy against the seizure of assets in the
I think it's an interesting question actually in the UK. So the prosecuting authority is required the disclosure regime to provide you with anything that they have which undermines their case or assists the defence, and reasonably assist the defence. But does that include intelligence? Because that's not in fact material that they can use. So it's interesting to note whether or not that would actually fall within the disclosure regime.
The gathering of evidence on both sides is complicated. We haven't really delved into the issue from the defense side individually, but remember over the last decade, we've had, an evolution in privilege, data privacy, labor laws. I vividly recall being in Frankfurt for that first Frankfurt Internal Investigations Conference and talking to people about how, the differences in privilege approach, the differences regarding, what you can and can't look at under various countries' labor laws. And I will tell you that it was fairly obvious from the interaction with the audience that that was news to a lot of people who have probably already been in many countries doing all of those things in ways they weren't supposed to. And we all know, as we look back 10 years later, there have been attorneys who have ended up being charged criminally in certain European jurisdictions for coming in and doing a U.S.-style investigation where labor laws, privilege laws, et cetera, data privacy laws just do not allow that. So again, we've been talking a lot about the government's perspective, but again, I think we see once again the issue here. Different jurisdictions approach this very differently, and so it's a really complex area because you can't adopt a single approach. It really has to be jurisdiction specific. Now, I've been holding the group back, this whole time because I wanted to get through a lot of different topics, but they really want to talk about DPAs, so this is it. We're going to talk about the evolution of DPAs because since we started doing these conferences 10 or so years ago, Brazil, France, the United Kingdom, Singapore, and Canada have adopted DPA or NPA models, and others, including Australia, are still considering them and may very well do this in short order. So how does that make the settlement regime look different? What's different over the last 10 years? Where is this heading next, now that we have this evolution and this use of DPAs? And Anand, I'll turn to you first to kind of kick off our conversation in this respect.
Yeah, so as I sort of alluded to already, I think DPAs have fundamentally shifted the way in which the SFO's enforcement has been undertaken in the last sort of 10 years. Since we've had them, there have been 12 DPAs the SFO have entered into. Most of them, it's true, relate to failure to prevent offences under the Bribery Act, but I think that's partly because that's what the companies want. They obviously want to portray it as a compliance failure rather than actually we committed some criminal conduct. But there have been 3 DPAs which are in relation to false accounting, fraud, or sort of real substantive criminal offences. They've yielded vast rewards in terms of financial settlements, into the hundreds of millions, and they tend to come first. So in most of the investigations, you will see the DPA entered into with the company first, and only subsequently does the SFO make a decision on charging individuals. So as I think, they shape the evolution of the case, and companies now are considering whether to self-report. I think is a normal course of events. 20 years ago, I don't think any company would consider whether to self-report, but that it is true that they've changed their mindset as a company, because the company does think, well, it's possible I can have finality in the resolution within a relatively short space of time, knowing that the only real impact is financial. So I do think that certainly in the UK, they've dramatic impact in terms of the way in which financial crime is investigated and prosecuted here. And on the other side of the scale, we've seen some spectacular failures in terms of court prosecutions, which have led to a reassessment of what we should be doing in terms of corporate criminal prosecution.
What do others think about the changes we've seen as a result of DPAs?
So in France, again, it did not come into play until very recently. So 2017 was La Loi 52. Since then, they've had 22 CG versus just versus 12. 10 of which were corruption related, the 9 are tax related, so on tax fraud. They are now an official ways of settlement for environmental infraction, as well as different issues of tax fraud and money laundering, of course. It is if you talk to people in the legal community in France, you have two big divides. It's either yes, I'm all for it because it is a speedy resolution, because it takes forever to go to a French court, and the impact on the company, reputation, resources, all of that is really bad. And the other one sees it as, a get out of jail free card, and they do not feel that there is enough prosecution, there's not enough defense. And then there is also the possibility of just, agreeing to something imposed upon you, which can be up to 30% of your average turnover for the last 33 years. It's not a small amount, just because you want to get out of it. So they are very much in the, I will take you to court, I will defend you, and we will win. Trust me on that. But you can also see the shift in the generation between people seeing the benefit of the CG, being able to, and the DD equivalent of DDA, being able to bring that matter to early conclusion versus just the concept of having to go through all of the process, the judicial process to take it to court. So we'll see what happens over the next couple of years on that.
We don't have DBAs in the Netherlands, but we do have the possibility to settle. I already touched on that a little bit. There are large settlements. There's actually a lot of settlements. What we see in the large settlements, like for ABN AMRO and ING, for example, but also that regard money laundering, but there's also a big one with regard to bribery abroad. Then the investigation is done. Witnesses are here, suspects are interviewed. And then at some point, of course, for the public prosecutor, and that's also a resource issue as well, it is handy not to bring a case to court because that will take a lot of time, a lot of resources. Defense would want to hear witnesses as well, probably. Self-reporting is, of course, also possible, only the issue is in the Netherlands that there's no official policy for cooperation at the credits. There's one example, which is the SHV concern regarding 294 bribery offences. Actually, in total they paid 41 million euro divided in 5 on the confiscation of illegally obtained profits. And then they got a discount of 25% because they self-reported and 25% because they cooperate. But if you set the standard very high, then it's, I think, quite easy to give a discount. But there's still no official policy because in the public prosecutor's office we see various opinions actually. There is a part of the prosecutors who see the advantage of providing cooperation credits, but there's another part that says quite strict. As a company, you have to adhere to the law, and we don't going to give you a discount for just doing what you should do as a good corporate citizen. So it's a discussion that's going on for years, and still there's no policy yet.
Amanda, do you have a last word on DBAs?
Just a couple of things, Reece. Obviously, from a corporate perspective, it's much easier to keep control of the timetable, or at least be involved in the timetable if you're doing an agreed settlement of some sort with the prosecuting authority. It's much easier to take control of the narrative, or at least be engaged in it, because although Anand says you'll agree to anything, at least you can negotiate it. What is and is not your red line, if you like. And the prosecuting authority has a real interest in agreeing something as well. So I think that's quite important. And obviously it's going to be, as a very starting point, or at least a foundation for when you are compromising or responding to civil and shareholder actions. So it's got really significant repercussions. That's the first thing I wanted to say. The second thing is that whereas there are a number of failing to prevent offences, over the last decade, the government in the UK has repeatedly said, whichever flavour of government, by the way, that they want to change or expand the way that corporate criminal liability is dealt with in this country, and to move away from the doctrine of identification, which requires the directing mind and will of the company to be involved in the criminality by doing the action or having the intention with the right acts, criminal acts. And so, very recently this year, the Law Commission responded to the latest effort in this regard, and they actually they've given an option statement described as to the government, and the option basically was keep the identification doctrine. And I think the government has been devastated because they really wanted to expand it. They also wanted to not just get a failing to prevent fraud, but to have failing to prevent everything, any offence that you want to do sort of corporate way into it by failing to prevent it. And I think that those sorts of offences, so I expect there will be a failing to prevent fraud offence in due course. And I think that that will open up even further the possibility of prosecution agreements, because for all the reasons I just said, and others have said, in terms of certainty and managing reputational risk, I think that it's almost always going to be in the best interest of the corporate to plead guilty or to agree a failing to prevent, but not in the best interest of the corporate to plead guilty if it's the identification doctrine, because it's so difficult in the modern world for the prosecuting authority to get the right proof in this country.
Well, and I think you're right. If you move to having this failing to prevent apply to everything, I'm not sure you're that much further away from respondeat superior, which is our system in the United States, where basically corporations are always responsible for anything their employees do. I mean, the respondeat superior system is very easy to satisfy, which leaves all of the discretion with the DOJ as whether you get charged or not. And I think, one of the trends that I see, think about the last 10 years or so in the US with DPAs, one of the things DPAs has done is to create sort of a faux case law, which is to say, here are all the things that companies have agreed to enter into a DPA for doing. We've never actually proven before a jury or before a court that these are crimes, but they've agreed that they will say it was a crime and plead guilty essentially through the DPA process. And the DOJ, if you look at their FCPA guidance, bases a lot of their guidance on these DPAs. But I'll also say that there's been a lot of people going to trial recently and a lot of people winning. And they've proven that some of these theories they don't hold up when you actually get into a court. So I think one of the things you're going to see probably, unfortunately, is that DPAs can create a style of law that creates some precedent, at least in decision-making models at corporations, but doesn't necessarily reflect what the law actually is. And that's definitely something we've seen in the U.S. We're just about out of time. Are there any questions from the audience before we wrap up for the day? I mean, I'm guessing no, because it's the reception next.
So honest answer.
One question.
Yes.
So it's just really picking up on what you said. So that this gap, this justice gap between convictions for companies, well, DPAs for companies, based on that identification principle, and yet no individuals ever convicted. So, how long are we going to allow this gap to continue? Because it's corrosive to confidence in the system. And obviously it changes the assessment of risk in the boardroom, where they're actually the wages to use that. So do we just allow it to continue because it suits it? Or if we don't implement it, how do we do it?
This is a man who said he definitely wasn't going to ask you a question.
It's a good question. Do you want to?
Well, I think it was interesting that the Law Commission came back with a keep the doctrine of identification. I don't think that the government, I don't think the DPP, I don't think that the Director of the Serious Fraud Office was expecting that. And it was really quite a significant sort of determination, really. And so I think the way forward is going to be that we will find that there is a gap, but the reason for the gap is a bit of is not exactly. It's not that it's impossible logically to explain. It's that you're actually looking at the same issue from completely different perspectives, and you're trying to squeeze one of those perspectives to work for both of the situations, and they're not the same. I mean, the most basic and obvious point is the individuals are nothing to do with the DPA. They've got no possibility of saying anything to influence the DPA, and quite often, as we all agreed, it's in the corporate's interest to agree a DPA, even if they are, perhaps particularly if they are throwing some people under the bus.
And I think that I cynically believe that the way that there's going to be the gaps will be closed in the same way that we close every gap where we haven't got the ability or the appetite or the resources to prosecute criminally. We find another disruptive way to do it. I explained well as account freezing orders. So we find other mechanisms which don't require you to prosecute somebody, but which achieve the ultimate practical aim that you want, the forfeiture of their property, the exclusion of them from the financial system, and you do it that way because the law commission says you shouldn't have the general failure to prevent offence if the only reason for having it is because you are unable to effectively gather the evidence and prosecute corporations. You should have it if there is a good reason to expect they should put in place reasonable prevention procedures for a particular type of offences. So my cynical view is that what we will do to close the gap is simply find more of these alternative measures which are not criminal but carry potential criminal consequences or those types of things. And that's what we will use to try and achieve the aim that we can't actually do in the way we should do by prosecuting.
Well, and that is in a way taking the DPA model and just applying it to individuals as well. I mean, the DPA is quasi-criminal. We think back to the U.S. financial crisis. There really weren't individual prosecutions. I think personally not that the DOJ didn't want to prosecute anybody because they just couldn't. They just could not put together the evidence to do so. But they could convince a bunch of corporations to enter into a settlement agreement to bring an end and a resolution to a matter. And I think that's where we are. We're sort of in a world where there's going to be quasi-creative ways to deal with issues that maybe don't look like traditional crime, particularly if you're in a system where the burdens are very high. All right, with that, please join me in thanking our panel.